The court is ready to hear argument in 19-662, Henry Oncor Electric Delivery Company, a petition for writ of mandamus from Dallas County and the Fifth Court of Appeals District.
May it please the court. Mr. Wise will present argument for relator. Mr. Davis will present argument for the amicus. Relator has reserved 5 minutes for rebuttal. Mr. Wise will open with the first 10 minutes and will present the rebuttal.
Chief Justice, may I begin?
Yes, please.
Yes. Before I begin my formal presentation, I wanted to cover, excuse me, 2 points that were made in the prior argument. Unsurprisingly, I listened to it. The first question was, Chief Justice, you asked for an example of what it would look like if a case was sent to the PUC. And there is a case that was sent to the PUC. It's a Giovanni Holmes v. Oncor case. And that case was prosecuted fully in the PUC. And it's now pending in the first level of appeal in the Austin Court of Appeal. And the style of the case is Giovanni Holmes versus Oncor. And the number is D1-GN-19-007049. So that case is completely proceeded through the PUC, and the court, if it wants to see the PUC order and various ALJ orders, that's available.
And so in that situation, did the administrative board make a determination about liability and a damages amount?
No, Your Honor. The PUC made determinations specifically related to issues within its jurisdiction, such as, and I didn't handle the case, so you'll have to forgive me if I'm not that familiar with it, but it made determinations, for example, whether Oncor timely provided services. It made determinations regarding who had to pay for certain type of construction services, whether it was the customer or Oncor had to do it. So it made determinations specifically about operations and services. In that case, it did not decide the ultimate issue as to whether there was a breach of contract. That will go back to the trial court once the administrative appeals are exhausted.
So that wasn't a tort case?
No, well, it is and it isn't. The issues that were sent to the PUC were a breach of contract. There's also a trespass claim, which the PUC did not decide any related issues. And then the other thing I wanted to address at the outset, Justice Hecht asked who makes the decision as to whether the PUC has jurisdiction. And that's a two-part answer or two-part process. First, the trial court will have to rule on the plea to the jurisdiction. If the trial court grants the plea to the jurisdiction, the matter goes to the PUC. The PUC will decide whether there are any issues within its jurisdiction. As the court recognized in Chaparral, the PUC doesn't have jurisdiction to decide ultimate issues such as breach of contract, negligence, violations of the TPA, or to award damages.
Mr. Wise,
yes,
plaintiffs argue that contrary to Oncor's position in this case, Chaparral did not change existing Texas law regarding exclusive original jurisdiction, didn't overrule those cases. We didn't side with approval another recent case that held to the contrary.
And I think that's wrong, Justice Guzman.
Why?
All the cases that the plaintiffs, that Mr. Taylor relies on, are very old cases. They were decided before Chaparral. All of them but one was decided before the court came up with the hybrid claims resolution process in the David McDavid case.
Did it approve or overrule those cases though in Chaparral?
By implication, it did. And the court can look at the fact that one of the principal cases that Mr. Taylor relies on is the Penny versus Southwestern Bell case. That case was discussed specifically in Chaparral, and the plaintiff in Chaparral, like Mr. Taylor, argued that the PUC doesn't have jurisdiction because the PUC can't decide the ultimate issue, which in Chaparral was whether there was a breach of contract. Here it's whether there was negligence or a DTPA violation, and also argued that the PUC doesn't have jurisdiction because it can't award damages. This court in Chaparral expressly rejected both of those arguments and overruled or disapproved of the reasoning in Penny. And in Penny, the reason the court found that there was no jurisdiction was because the PUC could not decide the tort or DTPA ultimate issues and could not award damages. So I think the bottom line is the ruling in Chaparral is entirely inconsistent with every case that Mr. Taylor relies on. This court, go ahead, Justice Guzman.
Even if you're right, they argue there's an exception that this.
Yes, Your Honor. What they argue is that they call it the Chaparral exception. Chaparral did not create an exception. In Chaparral, Chaparral applied a long-standing exception to exclusive jurisdiction of administrative agencies. That is the exception in the Houston Federation of Teachers case. And that's the inadequate remedies exception that applies when a plaintiff is seeking injunctive relief and the administrative agency cannot grant that relief. And in this case, Mr. Taylor, just like the plaintiff in Chaparral, is not seeking injunctive relief. He's seeking money damages. This court in Chaparral held that that exception does not apply. There's another exception that was created by this court in the Foree case, F-O-R-E-E. And that exception applies solely to primary jurisdiction. And what it says is that if the administrative agency can't give the ultimate relief and cannot decide incidental issues, primary jurisdiction doesn't apply. Even if the court were to—
what are the specific issues that you want the PUC to decide here, and what statutory or regulatory language governs those issues?
Well, Your Honor, I think, as we point out in our brief, the plaintiff is claiming that almost every one of his claims, his negligence, DTPA, premises liability, and trespass claim, involve violations of Oncor's tariff. Oncor's tariff is the uniform tariff that's adopted by the PUC. For example, in his summary judgment motion, Mr. Taylor is claiming that we violated section 5.7.7 of the tariff because it requires Oncor to relocate a service drop at its expense. It requires Oncor to respond to certain requests within a period of time. It requires Oncor to trim the trees around electric lines and service drops. And the issue in our case is many of the issues involve interpretations of the Oncor tariff, which is really the PUC uniform tariff, and therefore the PUC, not a jury, should be interpreting the tariff. And I think Chaparral, the basis for the Chaparral conclusion that the issues there involved services and operations was the fact that there were issues regarding the application and interpretation of the tariff.
And is your position that the tariff does not actually require you to do the things that the plaintiff is saying it requires you to do, and that if that's right, you don't owe the plaintiff the duties that he's claiming, and therefore he loses? Is that your position?
Our position is that the tariff does not require us to do certain things that he requires us to do. Whether or not there's a duty, if the PUC rules in our favor, is a question for the trial court. The PUC is not going to decide.
What difference does it make whether the tariff requires you to do it if that's not determinative of your tort duty?
Well, Your Honor, our position would be that it is determinative of our tort duty, but the PUC doesn't have the jurisdiction to decide that issue. That's a question. What the PUC will do is it will take the findings and conclusions. What the court will do will take the findings and conclusions of the PUC and apply them to the legal issues, negligence.
So what if the district court decided that the meaning of the tariff is not determinative of your tort duties? Why would the meaning of the tariff have anything to do with the case? I mean, why would you bother to go to the PUC if the court decides that the meaning of the tariff doesn't affect the duties you owed the plaintiff?
Well, Your Honor, we believe the PUC will decide those issues directly. For example, the PUC will decide whether we responded promptly, whether we have a duty to trim vegetation around service drops. If it decides those issues in our favor, our position in the trial court is going to be that the claims that are based on those violations, there was no duty, there is no cause of action. If the trial court says, I disagree, then we're going to have to try the case and take that up on appeal. But we think those issues, if the trial court acts properly, will be dispositive of all or many of the claims. But until the PUC rules, we don't know that, and then the court has to apply the legal finding, the legal conclusions and the findings of the PUC properly. At least we hope properly.
Any other questions? Thank you, Mr. Wise. We'll hear from the state.
Thank you, Mr. Chief Justice, and may it please the court. If I could just start with the distinction or potential distinction between tort and contract claims. I think the analysis should focus on the subject matter based grant of jurisdiction in 32.001. There's no basis there to distinguish between tort and contract claims. And if I could give an example of, I think that illustrates that. Let's say that there's a utility that's under contract to construct a power station, and part of the contract requires it to properly install safety devices, and they're not properly installed. Well, it's a breach of contract, but it could also lead to personal injury, damages, and tort. And there would be common issues underlying both of those claims that under the text of the statute in this court's decision in Chaparral would be properly before the commission.
But Mr. Davis, if the commission hasn't regulated how to install the safety devices, then isn't the commission just deciding what the jury would decide?
Well, no, Your Honor. And I think this goes back to a point from the previous argument about the nature of this grant of jurisdiction. And if I could say just a little bit more in contrast to the statute in Subaru. The statute in Subaru granted exclusive jurisdiction over the Motor Vehicles Board to regulate as provided by this act. And on page 223 of the court's opinion there, the court found that significant, and the reference to specific provisions of the act or the act meant that the court needed to look for provisions governing that. But here we don't have that language. We have a very broad grant of exclusive jurisdiction based on subject matter that's not dependent on specific provisions. I will say, though, that—
So you think that the commission can decide the ultimate issue of negligence, for example, and that shouldn't go back to the trial court because it's within the commission's exclusive jurisdiction?
No, Your Honor, I think under the hybrid model, I think the issues need to be separated out from the claims. And so it's not the claims that are going to the commission. It's issues that implicate rates, operations, or services, as those terms are broadly defined. And just to return to the point about the statute, there is a provision here, section 38.004, that talks about minimal line clearance and compliance with the National Electrical Safety Code. So to the extent the court would require a reference to that, again, in our view, in the state's view, that's not necessary given the nature of this jurisdictional grant. It is in the code. And to the extent that
Mr. Davis, there are a lot of cases that rely on the Electric Safety Code for the standard of care, or for evidence of breach of the standard of care. Are you saying all of those cases would fall within the PUC's ambit because they've included it in their regulatory scheme?
Well, the jurisdictional question is whether there are issues relating to the rates, operations, or services. And so
and is the interpretation of the electric code, in your view, something that relates to the rates, operation, and services of an electric utility?
Presumably, I guess I would need to know what the facts of the case were. But if there is an issue relating to one of those three broadly defined terms that's necessary to resolution of the claim, then whether we think that's the right result or not, that's what the statute and this court's precedent compels.
So were we wrong to say that somebody driving to a job site doesn't fall within the, if they're negligent and hurt somebody, that doesn't fall within the PUC's exclusive jurisdiction? Because it seems like under the broadest reading of services, it would fit within that.
Yeah, I think, it's potentially falling within operations or services. And I guess the question there would be, is there an issue in that case that's necessary to resolution of the claim? Can the utility identify something that the commission needs to resolve or not? And if there are no relevant issues, then it wouldn't fall within that scope in the state's view.
Well, that's why I was asking if there was a regulation or something from the PUC on point rather than just sort of a general negligence standard. But it seemed like you thought that we shouldn't be asking that.
Well, I mean, here, I think this is not all that hard of a case because we have the plaintiffs in response to a motion for summary judgment relying on tariff provisions. And we know from Chaparral that that's significant to the analysis. I see my time has expired.
Any other questions? Thank you, Mr. Davis. We'll hear from the real party.
May it please the court, Mr. Hatchett will present argument for the real party in interest.
May it please the court. In Oncor Electric Delivery Company LLC versus Chaparral Energy LLC, this court said, all regulatory schemes have limitations. All three of these cases set for oral argument today are about drawing lines, and I think the court has recognized that in its questioning so far. The question for this court to decide is, where did the Texas legislature draw that jurisdictional line under the Public Utility Regulatory Act in 1975? The paramount goal of statutory construction is to ascertain legislative intent. We know what the legislature intended when it enacted the PURA because it told us. That purpose statement, which is currently in section 11.002 of the Texas Utilities Code, states, public utilities traditionally are, by definition, monopolies in the areas they serve. As a result, the normal forces of competition that regulate prices in a free enterprise society do not operate. Public agencies regulate utility rates, operations, and services as a substitute for competition. The legislature intended the PUC to regulate the business affairs of utilities as a, quote, substitute for competition. And that means only claims based on rights created by or found in the PURA, PUC regulations, or a utilities tariff should be decided by the PUC.
Is it your position, counsel, that that at least one of the duties that the defendant breached was a duty imposed by the tariff?
It was not It is a duty that was imposed by the tariff, but our clients are not asserting claims with rights that arise from the tariff. And I think that's an important distinction because this court is familiar with a test like that, the one that I just articulated, looking at the source of the right to determine whether there's jurisdiction in the courts or, as this court has decided in the past, in arbitration tribunals. In direct benefits estoppel cases, this court is very familiar with looking at whether or not the source of a right arose from the contract in which the arbitration clause is found. The Jody James Farms case that Justice Guzman authored just a few years ago applies this test. It's a reliable test that this court is familiar with, and it's easy to distinguish between what claims are supposed to go to the PUC under 32.001A in the PURA and ones that are not. I think one of the distinctions that can be drawn between the position that our clients hope the court adopts and the one advocated by Oncor and the state is that there is going to be a test that can be reliably applied in the future. The state and Oncor are both asking this court to adopt a framework that requires future cases to be decided on a case-by-case basis. That is going to increase load in the trial court and indisputably is going to increase the number of cases that go to the PUC. Both the state and Mr. Taylor agree that the PURA as a whole should be interpreted and applied when this court decides the exclusive original jurisdiction of the PUC. The default, as this court acknowledged in Justice Boyd's opinion in Chaparral Energy, is that the district court is constitutionally enabled and authorized to decide disputes. That's where we start. And then from there, we ask, did the legislature clearly and unequivocally create jurisdiction for the agency over these claims? I think it's also important to start on that point to discuss something that Mr. Wise said. Chaparral Energy has not decided this case. Chaparral Energy did not overrule any of the cases that held rights based on common law or on statutes that are not promulgated or enforced by the PUC, do not belong in front of the PUC. In response to Justice Guzman's concerns, the Chaparral Energy case applied consistent, long-standing Texas law that said that if a case would be decided, unequivocally decided in Chaparral Energy by application of the tariff, did the tariff overrule and supersede the contract between the ratepayer and the utility, then that's game over. And I think this goes to some of the questions that Justice Busby and Justice Blacklock had earlier. There is not going to be any decision rendered by the PUC in this case that will be dispositive of our claims.
Could the PUC decide that the tariff did modify the common law duty that you're relying on? And if so, shouldn't the PUC be allowed to decide that?
It's possible that the PUC could make decisions that are relevant to the case. And I think that was a question that Justice Boyd had asked earlier. That is not the determinative issue in our view. Just because the PUC may say something that is relevant doesn't mean that it has jurisdiction, exclusive original jurisdiction to decide the case. That's why we need to look at the phrase.
I'm not suggesting that they should decide the whole case, but that there might be a particular issue that they should decide that would then the trial court would use to decide, or the jury to decide the case.
And I understand your question, Justice Busby. I think that is going to be determined by the interpretation of rates, operations, and services. And that is, I believe, something that has not really been discussed a lot yet during these arguments. Our client believes that the more accurate view to what the legislature intended when they use that phrase is to look at it as a phrase and not as individual words. In the state's brief, they used the phrase battleground term. The battleground is going to be operations. I don't think that that's the best way to look at this to determine legislative intent. You have to look at the entire phrase rates, operations, and services, because if you look at them individually, you're going to have to come to the conclusion that the PUC has exclusive original jurisdiction over everything a utility does, because as Justice Busby mentioned earlier, service is defined to have its broadest and most inclusive term. It goes on to say, the term includes any act performed, anything supplied, and any facilities used or supplied by a public utility in the performance of the utility's duties under this title to its patrons, employees, other public utilities, an electric cooperative, and the public. That is literally everything a utility does. Nobody in this case, the state, Oncor, or us, agrees, and nothing from this court's decisions in the past compels the conclusion that the PUC has exclusive original jurisdiction over everything a utility does. That cannot be what the legislature meant. We cannot look at these individual words by themselves in isolation to try to determine legislative intent for the PUC's jurisdiction. That's why it's important, as the state agrees, to look at the PURA as a whole. And as a whole, including the purpose statement, we know that the legislature intended the PUC to decide issues regarding a utility's business affairs because it was brought into existence to regulate a former monopoly. That's how the phrase appears, rates, operations, and services, throughout the PURA. It's used 13 times. I've looked at every single one of them. Not every one of them provides some context, but most mention competition, being just and reasonable to consumers, things that you would associate with regulating the business affairs of the company, not the safety regulations that you would have over the utilities and its interactions with the general public.
Counsel, let me ask you something. Is it your position that the nature of the duties imposed on Oncor by the tariff and whether or not the tariff has been complied with, are those questions immaterial to your case?
No, they're not immaterial. And I think this is consistent with what I was talking about with Justice Busby, Justice Blacklock. Just because there are the tariff may be relevant doesn't mean that confers jurisdiction under the statute to the PUC. And I think a very good way to think about this is in Justice
can I interrupt you
Guzman's.
there? So do you agree that somebody needs to decide what duties the tariff imposes on Oncor in this case?
Somebody will, and we're going to ask somebody to make that decision.
Okay.
I think a good way to look at this, because there is, I understand, a desire to have the PUC make uniform decisions about some of these issues. But just because the tariff is mentioned doesn't mean exclusive original jurisdiction is conferred over claims. I think a good way, an analogy to this, an analogous situation, would be that Jody James Farms case. Justice Guzman wrote, just because the contract is referred to doesn't mean that the claim arose in reference to the contract. There was no direct benefits estoppel in that case because the claim being asserted was not based on the contract. The claim mentioned the contract was relevant to the claim, but the right being asserted was not based in the contract. And that is going to be a way that this court can decide and give guidance to Texas courts in the future about how to make these decisions. Otherwise, there's going to be widespread consequences as a result of this of a decision saying that all issues that could potentially be decided by the PUC must go to the PUC. The state, in its brief, outlined a process that would require 2 or potentially 3 different lawsuits in order to decide a case or a claim. The first would have to be filed in district court. There would be a plea to the jurisdiction where it would either be dismissed without prejudice or abated. We go to the PUC for proceedings. There is an administrative lawsuit to challenge on a substantial evidence basis findings by the agency, and then potentially a third lawsuit that's filed in court. In addition to that, we presented evidence that was not disputed that claims by or against Oncor, formal complaints by or against Oncor would have increased more than 1,200% at the PUC over the last 5 years. The PUC is not equipped to handle cases like that. We submitted and exchanged discussions with the Office of the Attorney General and the Solicitor General's office before this, requesting additional information that was not provided. So the only thing before the court are the statistics that we gave you. I think it's also important too to recognize the source of the David McDavid decision, the Subaru of America versus David McDavid decision that has been cited by Oncor for this hybrid approach. In that opinion, Justice Baker rejected an open courts argument that David McDavid was having its open courts rights violated because it was being sent to the Texas Motor Vehicle Commission. Importantly, Justice Baker said there is no violation because the only reason David McDavid had a right to operate a dealership was based on the code. It was not based on the common law. This is a different situation, different in kind, and should result in a different application because we do have rights that were based on the common law. And that is the reason and the logic behind the test that Mr. Taylor is proposing. When you have claims that have rights that arise from the common law or statutes or that are not promulgated by or enforced by the PUC, that is an easy line for the court to draw, and it's consistent with this court's prior decisions in David McDavid and in Chaparral Energy, and it reduces impact on both the PUC and the courts by not upsetting the balance of how those cases have been distributed over the last 45 years of the PURA's existence.
Mr. Hatchett, the tariff can alter the common law duties though, right?
Yes, obviously, Your Honor, the legislature can pass statutes that alter the common law, and
right, but I'm just talking about what the PUC can do through the tariff itself. That can alter the common law duties, right?
it can.
Okay,
I'm not.
So why shouldn't the PUC decide if it has in this case?
The PUC, the right to assert the claims has not been affected by the tariff. Nobody in this case is claiming that the tariff.
And I'm not suggesting that it altered the common law to bar the claim, but can it alter the standard or the scope of the common law duty, like whether, who has the duty specifically with respect to trimming the trees?
It can. And my response to that would be the same as your earlier question, Justice Busby, that just because that the PUC could make relevant findings does not mean that exclusive original jurisdiction has been conferred on the PUC over the claim. Also, just to be clear,
but what about the issue? I mean, does it have to be analyzed on a claim by claim basis, or can it be analyzed, should it be analyzed on an issue by issue basis?
I don't believe that's what the legislature intended, Your Honor. I don't think that's what rates, operations, and services means, given the interpretation of the PURA as a whole. I understand that there is an argument for that is being made by Mr. Wise and Oncor. I don't think that that's consistent with the legislative intent and would further provide big procedural and logistical hurdles for this court to implement. An easier way, a simpler way, a more consistent way to do this on a go-forward basis is to determine where a lawsuit goes or where claims go based on the source of the right that's being asserted.
It seems though that if you did it that way, you could end up with several different determinations from several different courts about the obligations of utilities under their filed tariffs to to trim trees at a certain place or a certain time, or there's thousands, maybe millions of residential yards with power lines going through the back of them. And it seems like the need for uniformity and for PUC clarity as to what those obligations are is pretty clear in this context. You see the problem of there being multiple conflicting determinations of what those obligations are.
I do understand that, Justice Blacklock. Two things. The first is just because it could potentially present procedural or logistical issues for the utilities does not change the language of the statute. The statute controls rates, operations, and services, and what that means in regard to the PURA as a whole controls whether or not this is convenient or inconvenient for the utilities. Second, the PUC can have a voice in deciding that because these tariffs come up for renewal. If they want to be more clear about what is and what is not required by the tariff, they can make it clear when it is issued to the utilities. The other thing is, I know we've mentioned tree trimming a couple of times. I don't want to delve too far into the facts. That is a very good example of us not relying on things that the PUC would decide. Mr. Taylor's not relying on a portion of the tariff to decide that issue. It is based on Oncor's own internal guidelines and handbook that we allege that they violated in response to some of these requests. This ties into the question that Justice Guzman asked earlier about the 4E exception. There are going to be claims that are referred to the PUC that it cannot make any findings on that will go back to court. It is not essential to any claim for the PUC will not decide any issue that is essential to any of Mr. Taylor's claims. That is the exception that this court recognized in 4E, that it recognized in the Chaparral Energy case when it said that there's no dispute that the PUC will have to construe the tariff and the contract in order to decide the claims. That is not what we have here today. Even to the extent
Mr. Hatchett, when you talk about the source of the claim, are you drawing a distinction there between a claim for economic injury versus a claim for personal injury?
No, Your Honor. I believe that would probably be more accurately characterized as personal injury damages versus the source of the damages that our client suffered. What I'm trying to articulate is that whether or not the source of the right comes from, that is being asserted, your right of action, your cause of action comes from the common law or from statutes that are not promulgated or enforced by the PUC, that is the determining factor, regardless of what types of damages you have. If there are no further questions, I'll cede the rest of my time.
Any further questions? Thank you, Mr. Hatchett. Mr. Wise, I believe you have 5 minutes.
Yes, thank you, Your Honor. A couple things. First, Mr. Hatchett said that Chaparral had no effect on the earlier cases. That's simply wrong. As I indicated before, those cases in holding that the PUC did not have jurisdiction over tort and DTPA claims relied on the fact that the PUC could not decide the ultimate issue, whether there was negligence or a DTPA violation, and could not award damages. That was the identical argument made by the plaintiff in Chaparral, and it was expressly rejected by this court in Chaparral. And as I said, this court disapproved of one of the principal cases on which Mr. Taylor relies, the Penny case. A second point is Mr. Hatchett appears to be arguing that this case, that the PUC's jurisdiction should be determined on a claim-by-claim basis. Again, that is wholly inconsistent with what this court ruled in Chaparral. The PUC's jurisdiction is determined on an issue-by-issue basis. And if a claim, such as a negligence or a DTPA claim, involves issues concerning an electric utility's rates, operations, and services, such as the interpretation of the uniform tariff, such as whether or not a fuse is too big or too small, such as whether the utility has an obligation to trim trees in a particular area. Those underlying issues, not the ultimate issue of negligence or breach of contract or DTPA violations, have to be decided by the PUC. And as Mr. Hatchett admitted, in this case, to resolve this case, someone is going to have to determine the meaning of Oncor's tariff. And if this court doesn't let the PUC do it, what effectively it's going to do is destroy a uniform interpretation of the tariff which the PUC promulgates and subject every electric utility in this state to ad hoc regulation by jury verdict, so that Oncor, who operates in about 110 counties, will never know what the tariff means. So that CenterPoint, who operates in multiple counties, can't rely on any interpretation of the tariff because each county in which it operates, a court can interpret it differently.
You mentioned, Mr. Wise, that the plaintiff here has referred to the tariff repeatedly in pleadings and summary judgment proceedings. But if the plaintiff had been very careful not to do that and just stuck to negligence claims, the utility could nevertheless come in and say, well, but here's our tariff. And if properly construed, that affects these claims. Is that true?
Absolutely, Your Honor. And that's what happened in Chaparral. The plaintiff in Chaparral never claimed that Oncor violated its tariff. Its argument was that it had a 1 or 2 page contract with Oncor, and that Oncor violated the contract by not putting in electric service to its oil wells on a prompt basis. There was no reference to the tariff, but ultimately the tariff controlled when Oncor had to provide services, how it had to provide services, and this court recognized that. And
Mr. Wise, to follow up on that question, do you agree also that the court has a role as a threshold matter to, in the hypothetical that the chief offered, to decide whether the defendant is right that the tariff actually, the meaning of the tariff actually would make a difference, and that the court would not require the case to go to the PUC if the court determines that the defendant's wrong and that the tariff actually makes no difference?
The trial court has to make the initial determination on the plea to the jurisdiction. And it can make a determination, for example, in a simple car wreck case, Oncor is not claiming that the PUC has any jurisdiction. The court can determine that the case doesn't go to the PUC if Oncor or an electric utility, or even if a plaintiff thinks the case should go to the PUC, that person has the right to file a writ of mandamus to get review of the trial court's decision on that jurisdictional issue, or wait until the case is over and file an appeal. So you're absolutely right. The court does play a role, and it makes the initial determination, but it can be reviewed by the appellate courts.
Any other questions? Thank you, Mr. Wise. The case is submitted and the court will take a brief recess.